Professor Boersma, welcome. I wonder if I can begin by asking you to take an oath, state your name, position, and swear either an oath or an affirmation, please.
Absolutely.
And then we'll do that first. Thank you.
Sure. So my name is Associate Professor Martijn Boersma. I'm in the discipline of Work and Organizational Studies at the University of Sydney Business School. And I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Dr. Boersma, would you like to make a brief opening statement?
I would, thank you.
Please proceed.
Yes. Thank you, Chair and committee members, for the opportunity to appear before you today. My colleagues and myself, that is Associate Professor Stephen Claiborne and Professor Chris Wright from the University of Sydney Business School, have put quite a bit of research in the submission that we made to you. Our findings highlight systemic vulnerabilities that significantly increase the risk of severe exploitation, including modern slavery amongst workers in rural parts of New South Wales. Our research identifies a number of factors, which you can see on page 7 of your submission. Notably, the ones that we highlight are visa restrictions, geographic isolation, and language barriers as factors that heighten vulnerability. Temporary migrant workers frequently find their mobility and employment choices severely restricted, exacerbating their dependence on specific employers. This dependency intensifies when employers control this dependency intensifies when employers control workers' accommodation, which is also often substandard and exploitative. Inadequate regulatory oversight compounds these issues, allowing exploitation to persist largely unchecked. Existing mechanisms at both state and federal levels are insufficient and inadequately resourced, meaning many exploitation cases go unnoticed or unresolved. Now, in short, we argue for possibly New South Wales supplementing federal support schemes, or at least actively advocating with the federal government to protect workers through amendments to federal schemes. We argue for the establishment of a labour hire licensing regime in New South Wales, as has been the case in other jurisdictions in Australia, enhanced data sharing protocols, developing a housing strategy that reduces migrant workers' dependency on employer-provided accommodation, planning for climate change impacts and their subsequent impact on workers in rural areas, and finally, and most noteworthy, they're all noteworthy, but this one is noteworthy because just this morning in the Sydney Morning Herald there was in the ABC, a report by an ANU scholar, Lindsay Kanan, specifically looking at the issues that women experience that are in Australia as part of the PALM scheme. I'm sure previous people providing testimony today have highlighted that research, and that goes to the 6th recommendation that we make, which is to implement intersectionally conscious policies and protocols. And thank you, and I welcome any questions that you might have.
Thank you very much, Dr. Boersma. And I might start. Strengthening labour hire regulation has been a constant theme since we started, actually big theme today. Dr. Kane has made a suggestion that perhaps we could act quickly and require companies operating, I may be actually misinterpreting your words here, but I'll put it out here,
Yeah,
Dr. Kane.
I think you're right.
Yeah, that we might actually require any labour hire company operating in New South Wales to actually be licensed in either Victoria or Queensland as a rapid step. I'm just interested in your reflections on that and the complexities of that, and any other thoughts you might have about how we might move rapidly to introduce some scheme, because there's actually a very strong now sense of evidence, I think, from all the people that we've heard so far, that this is a really urgent matter. And as I said this morning, we've already raised it with the Attorney General. So any reflections on that, please?
That's a good point, and it's obviously easy for me and my colleagues to put forward a suggestion like that. But we did reflect on possible timelines and the steps that would have to take place. And I think the suggestion by Dr. Kane makes a lot of sense. Something that we had suggested ourselves would be to have an interim labor licensing scheme, or at least something that sort of has the bare bones of what a licensing scheme would look like based on what other states have already done, and roll that out before you ultimately, in a longer period of time, come out with a comprehensive scheme. The good thing, I suppose, about New South Wales not having a dedicated scheme yet is that you don't have to, reinvent the wheel. You can look at what's been happening in other states, what has worked, what has not worked, and there are obviously a number of forums through which you can, the responsible minister could engage their counterpart in a different state to I suppose, gather that information and apply it in New South Wales. But certainly the solution put forward by Professor Kane, I was going to say. Congratulations on your promotion. Dr. Kane, that would make a lot of sense, I would think, yeah.
Thank you.
Thank you. Dr. Kane, do you want to
I have a
follow up or ask further questions?
I have a follow-up question. One of the criticisms of my otherwise very worthy suggestion that the chair has just summarised would be, yes, but you would still need to have some kind of enforcement. So even if we adopted, we accepted the licensing of other states, you would still need some on-the-ground enforcement. And we've had this conversation in other committees about enforcement. So I wanted to start by asking you, what steps could we take in New South Wales to close enforcement gaps? And we don't want to create any more either. That close the gaps that do enable the kind of exploitation that we've been talking about.
Yeah. No, that's a good question. And fortunately, me and my colleagues also reflected on, who would be responsible for the enforcement. There are a number of candidates there, but one of the things that also crossed our minds is that you can also have like a cross-agency task force doing that in sort of the opening stages of a labour hire scheme. Agencies that came to mind were New South Wales Fair Trading. There might be a role for Safe Work New South Wales. Obviously, New South Wales Industrial Relations would be a candidate that are there as well. But also knowing that many of those agencies would already be stretched in terms of resources, manpower, etc. So it would be a possibility to set up a sort of cross-agency task force that could do that in a more informal way in the opening stages of a scheme in New South Wales.
Thank you. Part of the issue we've had with this discussion, and we spoke about it last hearing day as well, is, of course, the cross-jurisdictional issues. So, we're talking about what happens in the state, but it's really kind of schemes are run federally. So how do we kind of deal with that in your experience and through what you've seen in the research that you investigated?
Yeah, that's a very good question. And I think obviously one of the recommendations that we make in our submission as well is about data sharing. And again, I'm fully conscious of the fact that that's something that's really easily said, but interagency data sharing, especially in the different jurisdictions, can be quite challenging. On top of that, obviously there has been a commitment, I suppose, from the federal government to come up with a national labour licensing scheme of sorts. So you could make the argument, and I was actually I prepared to field that question about, wouldn't a federal scheme then supersede any national scheme? The problem with the relying on a national scheme is that we are obviously not aware of the time frame in which that might occur. Obviously, Queensland recently has seen some due to change in government, their scheme obviously has been delayed by quite a bit, as far as I understand it. The urgency with which much evidence was presented as well today, what I would say would necessitate the introduction of a New South Wales scheme. And again, not having been part of these forums, but the COAG or the what's the acronym again? COAG.
Council of Australian Government.
That's right. Yes, and several ministerial councils as well could be used as forums to, I suppose, have this interjurisdictional cross-pollination where you could, I suppose, again, sift out what was the problem with the introduction of these schemes and how it might work going forward, and what would also be the complexities of having different schemes at different levels, so at state level and the federal level. But that in itself, I don't think, should be a major problem in implementing a scheme. Yeah.
I've got more questions, but I'm conscious of time. Do you want me to keep going?
Why don't we go to Ms. McDonald? We'll come back to you, Dr. Kane.
Thank you.
Thank you. How can local councils and NGOs be integrated into the enforcement and support ecosystem, but without overburdening already thin resources?
I'm very happy that you mentioned the overburdening of NGOs, because I've worked with quite a few NGOs, and yeah, they are experiencing. It's almost like the enforcement has in part been outsourced to them, and so they're overstretched, under resourced. But they are such a vital part of the outreach in the communities, and as are the local councils, obviously. I think in large part that is about. Well, it's about funding in the first place. I think that, at least to my knowledge, federally, there has been quite some support after the introduction of the Federal Modern Slavery Act to try and see what NGOs would need in order to help to effectively enforce the Modern Slavery Act. I think that. And so the funding is always, I suppose, what it comes down to with civil society and NGOs at the end of the day. But I think for the government to effectively, facilitate forums where it is possible for local councils and NGOs and other stakeholders to build capacity and to learn from one another, I think that would be very, very important. I think that has, to a degree, already happened. But if I was listening to the evidence just before being provided about people that would just seated here, for example, is it the community connections, I believe they referred to, where there was one person who was basically servicing half the state. I don't know how they do it, but so I think that in large part it's about capacity building and upskilling, but potentially, and this comes back to one of the points that we made in our submission as well, is to provide appropriate training to people for whom this might be relatively new. You might be on local council and not really have had any experience with this, and that experience does reside in civil society, but obviously they are overstretched and they can't just provide training to anyone. On that, if you indulge me, on that topic of training, I do think that, and this has been mentioned by previous people providing evidence, not just today, but I think last time as well, among which the Office of the New South Wales Anti-Slavery Commissioner, is to roll out, standardized training that is specifically tailored to people in rural areas, people that might be on local council, and people that might be far away from the metropolitan service provision, because I think that is something that's been stated quite a bit as well, that the legal services, the assistance, the crisis accommodation, etc., like a lot of that is quite focused on metropolitan areas and absent in rural areas. But to come back to your question, that is a question of funding, but also I think for government to provide, to facilitate forums where all those different stakeholders rurally can come together and form networks that facilitate knowledge sharing and capacity building.
Dr. Kane.
Thank you. Associate Professor Boersma, I've got a question which is a bit more sort of theoretical, and it just came to me while I was listening to the previous witnesses, and I suspect it's something that you've thought about quite a bit given your area of scholarship. There's a bit of a tension around the PALM scheme or other sort of visas, where workers from countries where labour standards are not as good as Australia, where pay isn't as good, come to Australia and experience an environment where the wages and conditions might be better, but are still substandard in the Australian context. And so you obviously don't want to deny people opportunities, which are certainly better than they have at home, but it's that dilemma of relativity. And I just wondered if you had any reflections on that. I know it's a bit of a left field one, but I suspect you've thought about it quite a bit.
Yeah, no, absolutely. I think that clearly for people coming from Pacific Island nations or elsewhere to come and work in agriculture, the money they make in Australia, which oftentimes obviously they send back with remittances as well, is significant. But that doesn't take away from the fact that people should still be paid a legal minimum wage. And I think that some of the evidence that we've seen in the submissions that I've seen as well, surveys that been done under among 15,000 plus migrant workers say that 75% of them didn't get paid the minimum wage. So for me, the fact that they would earn more here than they would elsewhere, or this provides an economic opportunity for them, obviously can never excuse illegal behavior by any employer. And if I may expand on that, given the fact that you mentioned sort of the theoretical nature of the question, when I teach my students at the University of Sydney Business School about particularly the difficulties in the agricultural sector in Australia and the exploitation that takes place, I first take them all the way back to sort of blackboarding practices of the past. I take them back to those types of exploitation, and I ask them to sort of break down sort of in key points what to think, what the issue is. And obviously with blackbirding, there's the abduction and the kidnapping. But ultimately, when we strip all of that back, it's about the lack of mobility or the option to move that a worker experiences and the disproportionate power that an employer has. And obviously, I'm not here to make a like-for-like comparison between blackbirding and sort of the modern slavery or modern slavery-like conditions that we would encounter on farms. But the point is that, if you look at the freedom afforded to, let's call it a domestic worker, for lack of a better term, versus someone who's here on a temporary migrant visa, the limited capacity they have to make decisions, the limited capacity they have to raise a voice, to engage worker organizations that might help them, such as unions or civil society organizations. And still, despite the changes made to the Palm scheme recently, the disproportionate power that resides with the employer, then ultimately sort of the ingredients for that recipe of exploitation, that those are still there. Yeah.
Thank you. Do I have more questions?
Yes,
Jeff?
you can have another one.
Thank you. You mentioned the article today, I think it was on ABC,
Yeah.
about the experience of women being unable to access healthcare. And I know you do mention in your recommendations the sort of intersectionality being important. But I just wondered, again, we are trying to think about what we can do in our jurisdiction. So what, if any, sort of strategies or interventions did you and your colleagues come up with that you thought would be worth our consideration?
Yeah. So I think women are disproportionately affected by sexual harassment in the workplace. I think that's a given. I think we don't even have to look at all the what we can and we should, but all the evidence that's been provided and all the recommendations and the submissions to the committee. The point is that a lot of the research thus far thinks about sort of the exploited migrant workers in rural areas as sort of a homogeneous group. And if you sort of start to pick at that, and fortunately the very timely publication from Dr. Lindy Kane from ANU today outlines how women not only have to deal with these substandard working conditions, but also are subjected to requests for sexual favors to meet the work requirements in terms of, like, for example, the 88-day requirement to work in rural areas to sort of meet visa requirements, et cetera, et cetera. So, that is something that makes up one piece of the puzzle of the otherwise sort of the numerous, and obviously referring to page 7 of our submission, the numerous different factors that contribute to that overall risk profile. So within New South Wales jurisdiction, I would say, well, if anything falls within, for example, and I imagine that for Safe Work New South Wales that would be the case, anything to do with sexual harassment or the discrimination based on gender would be something that you could look at. And, because I think that also in terms of providing culturally sensitive but also gender sensitive support services, because as Dr. Kanan also outlined, the shame that's associated with sexual relations outside of marriage or falling pregnant indeed are obviously something that are borne by by migrant workers in those communities. So if that would be one part where I would say that's something where you could act, for example, through Safe Works New South Wales, because I do think that sexual harassment in the workplace would be part of their remit.
You're right.
I've got more, but you're
Can I just switch a bit now to how do we get data and the right information? The PALM scheme seems to be highly regulated. We know almost precisely how many people are supposed to be here. And yet we've just heard that even within that scheme, information doesn't necessarily go to all parts of it. Thinking of working holiday makers, I mean, it would seem to me that it is quite important to know where they're working, get some idea of that sort of information that might be shared amongst different agencies, so at least people would be aware perhaps of collections of working holiday makers or industries or firms. But I don't think that takes place at the moment. Is it a privacy thing that that doesn't get shared more broadly, even if it was not person-specific data, or is it just no one's thought to tell police that there are 100 working holiday makers currently involved in this particular area?
Yeah.
Is there any reflection you can make on that?
That's a good question. I think in part it is based on privacy, and particularly with the sensitive topic, obviously, with potential exploitation as well. The sharing of data. Obviously, someone who might be in an exploitative situation might share data or information, but on the premise that it doesn't get spread more widely. I think there's a lot of distrust typically of authorities as well, and fear obviously of repercussion as well from both the employer and authorities. But anecdotally, I taught the Modern Slavery and Human Trafficking postgraduate program, developed and taught at the University of Notre Dame, Australia, 2 years ago, and I had one very bright student who worked for the Australian Federal Police, and we engaged in quite lively discussions, because one of the things that we oftentimes talked about in class was, okay, how can we obviously do better in terms of public provision of services, and one of the things that always come down to was information sharing. So how does New South Wales Police share information with an AFP? How does that intersect with Border Force? How does that get outside of these channels potentially to civil society? How does civil society feed into that? And the sense that I got from her, quite explicit actually, was that was mostly just a cultural thing. That was sort of the interagency reluctance to share that type of information. So while I definitely see a privacy issue there as well, as you just started off by raising, from my colleague who again worked for the Australian and still works for the Australian Federal Police, that was mostly an interagency thing where that's just culturally not done to share that type of information. So I don't think that there is necessarily any structural limitations for that occurring. I think you just have to identify pathways for which that can occur.
Dr. Kane, I think you wanted to have one more question.
it might be one that takes a bit longer, so I can provide it on.
You sure?
Yeah.
And also, can I also ask whether you'd be able to give us any information? We had some evidence this morning. Let me start again. We've obviously talking about PALM scheme workers, working holiday makers, temporary migrant workers, but we had evidence this morning of people being recruited to come on tourist visas, who then are basically end up being told to, or taken through a pathway to get a protection visa, so they can then be basically put to work. Is that something that you've engaged with? That sort of outside any sort of visa? It sounds to me completely illegal.
Yeah, no, that does sound quite illegal to me. I've not known any cases specifically like the one you just mentioned, but one thing that we do mention in our submission is the role of crime syndicates around that as well, and sort of the notion that there would be a sort of a structural, more organized effort to circumvent visa restrictions, and I think that would also potentially actually coming back to your previous question, it might be a motivating factor for federal agencies to do some information sharing when there's a dimension of organized crime involved or there's crime syndicates where the issue itself seems to be elevated from, I'm going to say mere, but I'm going to do air quotes, mere worker exploitation towards illegal activity on an organized scale, which also intersects, for example, with drug cultivation as well, as we know. So that might be an instigating factor for some of those agencies to share more data. But the specific example that you mentioned, I'm sure it occurs, but I'm not familiar of any specific cases.
Okay, thank you. Thank you very much,
You're welcome.
Associate
Thank you.
Professor Boersma. Thank you very much.
Thank you.
We might excuse you and call our next witness.